A warm good day to you, my esteemed viewers. It is on my part a pleasure to welcome you to the 14th edition of your favorite Human Rights Series program on your one-in-all channel, HumanRightsHeralds. I am still your humble anchor, Ogochukwu Onoha. Welcome to the 14th edition of A Half Hour with the Human Rights Wizard. You know, as the common saying goes, knowledge is power, and knowledge and power help to liberate and emancipate us from the bondage of mental slavery. On our video today, we shall be focusing on the abuse of workers' rights and the available legal remedies. It is a follow-up to our immediate previous video, episode 13, where we discussed the Labor Act and the rights of workers. I would advise that you watch that video, episode 13, before you watch this, as this is a necessary corollary or a necessary follow-up to the issues analyzed on that video. If you are joining us for the first time, the channel is Human Rights Heralds, and it is a channel dedicated to helping all of us Nigerians understand our fundamental human rights, especially by breaking down, dissecting, or bringing to simpler terms the technical jargons used in the language of our written laws, so that the ordinary person, the lay person like us, will have a better appreciation of these laws, especially as these will help us understand our rights, understand our duties, and how duties and rights interact to create a just, orderly, and harmonious society. So, without further ado, let us talk about the abuse of workers and then the available legal remedies. On our video, on the 13th episode, we talked about who an employer or an employee is. The usual academic term for the employer is the entrepreneur, and the usual academic term for the employee or worker is the labor. The entrepreneur, a factor of production, hires the labor who renders his or her service as a contribution to the process of production and gets paid a sum of money negotiated as salary, stipend, or wage, whatever description it may go with. Doesn't matter. How are workers often abused in the workplace, even in the presence of a contract of employment, and sometimes in its absence? It doesn't matter. Now, let me first of all help us to understand the kind of business models that we have in Nigeria. I want you to recall our secondary school classes, where we discussed business models in subjects like commerce and business studies. we learned about the sole proprietorship, otherwise referred to as the one-man business. A business model established by an individual who is everything to that business. He does everything in the business. He is the seller, the cashier, the financial accountant, and name them. He is everything. He obtains his own supplies himself, does the sale, does the accounting, and everything else. Sole proprietorship. Then away from that, as we go upper in the ladder of entrepreneurship, we talk about partnerships, partnership businesses with all its various subdivisions, where two or more persons come together to own a business jointly. Then as we climb even further up the ladder, we now talk about limited liability companies. This PLC, or this limited. After which we talk about mega organizations like mergers and corporations, and so on and so forth. But there is a business model that exists only in Nigeria, to the best of my knowledge, that defies description. I mean, analysts have not been able to give a name to it, but I call it family business. It operates mainly in the private sector. In schools, for instance, private schools and other such private organizations, not just schools. But I would like to use the school system, the private school system, as a case study, because it is a system where I have worked for many years. The private school, a family business. Like I said, there is no business model called family business, but I have coined that term for it. It is a school, for instance, a secondary school or a primary school. The man owns it, or his wife owns it, or they own it jointly. And then there is no administrative structure. There is no administrative structure. The man, the owner, the entrepreneur, that's the employer, is the CEO. He is the managing director. He is the school accountant. He is the cashier. And he is the sales representative. He is the HRM, or human resources manager, or personnel manager. He is the school's advertising agent. He is the sales representative. In a nutshell, the owner of the school is everything. If money has to be spent to obtain supplies needed in administrative offices, he brings the money directly from his pocket. If he is not around, work has to stop if money is needed until he is there. It is called family business. When it comes to receiving income for the organization, this CEO everything either receive the money directly or appoints a close relation whom he trusts. And this is rarely the case, because such people rarely trust anybody. But sometimes, at least, there could be a close relation that the owner of the business makes some pretense of trusting, who we may call a cashier, who collects the money on his behalf. The other duties in the school, like watchman, that's a gateman, gatekeeping, cleaning, are all done by the owner of school through people he appointed to do it for him. People who don't have any official position, except that the boss has asked them to be doing this. So, someone acts as a principal, someone acts as a vice principal, someone acts as a dean of studies, someone acts as an accountant, someone acts as a cashier, someone acts as an advertising agent, someone acts as a sales manager, someone acts as the managing director. All of these people act, but their positions are not recognized anywhere officially. And there is no remuneration, there is no extra payment attached to the jobs they do. They do these jobs simply because they are employees and have to do whatever is assigned to them as a task. So there is no job description. What you're asked to do is what you do. I know this may sound ridiculous to you, especially if you are a greenhorn in the Nigerian industrial sector. But there is no joke there. People who are in the school system understand what I'm talking about very much. Now let us go ahead a little more. Now in such a system, of course, every pretense of orderliness or rules is jettisoned. The employer or entrepreneur simply does his thing his own way. He wakes up today and decides that you are a staff. He wakes up tomorrow and said, no, you are no longer a staff of the organization, and nothing happens. Someone arrives at the workplace late today, so he dismisses the person right away from the gate, and the person goes home. No formalities. Another person arrives late tomorrow. He simply decides that what he needs today is to cut the person's salary in half and give the person half. And he should be thanked for doing that, for at least retaining the staff. Everything I'm telling you is a personal experience I have noticed, I've witnessed in this kind of business model that I am talking about. Naturally, in such a business model, there will be no appointment paper. The staff is simply recruited. Interviews are conducted by the owner in the ways that he deems necessary. An appointment paper will be a problem if it exists, because it will make it impossible for the owner to act in ways he deems necessary. The appointment paper would bind him to certain agreements, to certain conduct, which is just one thing he does not want. So no appointment paper, no job description, no condition of service. He tells you how much he wants to pay you as salary. It's not negotiable. You either accept it or leave. No unionism. If a staff makes any pretense of encouraging others to form a union, a workers' union, such a staff is summarily dismissed. Dismissal is conducted haphazardly. A staff could be dismissed while a staff meeting is going on for arriving late or for doing something elsewhere in the premises earlier, and for which the owner had to wait until a meeting to dismiss him, so that it will be a demonstration before all the staff of how powerful he is. Because the dismissal cannot be done secretly, otherwise he's not a powerful man. So what I'm trying to say is that such an owner must be a powerful man. And then, so long as job exists in that organization, he has to prove each day under the sun, that he is a powerful man, one who is to be feared by the workers. There is no job description. So today, a worker could be asked to wash the boss's car. That's his job, a part of his job that day. Tomorrow, another worker could be sent to the market to buy provisions or to do shopping for the boss's wife. And sometimes a worker could be sent home to the boss's house to do some mopping and wash some clothes for the boss's children. And if there is an event in the establishment, say a school for instance, all women in the employ of the school become caterers. They have to spend a part of their night or the whole night in the school cooking coolers of rice that will be used to serve customers, that will be used to serve guests on the kitchen the next day, say a graduation ceremony. And some of the male teachers will have to run errands, going to the market to buy drinks, crates of drinks, and transporting them to the school, and loading and unloading them. That's a part of their job description. And those teachers who can communicate more fluently become the MC during the occasion. The school doesn't have to hire an external MC who has to be paid when there are teachers who could be used free of charge. This is interesting, isn't it? Now, this kind of business model operates in Nigeria. My investigation has not extended to other parts of Africa to find out whether it is a peculiarity of the Nigerian economic system or industrial sector. But that is the case in Nigeria. Now, perhaps the highlight, the climax of it is that staff members who prove to be stubborn, who dare to challenge the status quo, can be killed. Of course, usually using black power. Black power. And I have chanced to get information from a school proprietor, the so-called school owner, who I hear can arrange hired assassins to eliminate some staff members for trying to ruin his business by asserting the rights of the staff. And some employ poison or other forms of black power to eliminate such staff. Today, we are talking about the abuse of workers and the available legal remedies. And the scenario I have just painted is supposed to be the background to our discussion. If you are enjoying this video, please give it a thumbs up, like the video, subscribe to this channel in order to encourage us to do more, and share the video so that it can have a wider reach. Remember, you can leave your views, your opinions, your reactions on the comment section, or send me an email to humanrightsheralds.wizard@gmail.com, or give me a WhatsApp post using the WhatsApp number 091-333-01790. Now let's have a brief review of a part of our discussion on our immediate past video. The video captioned the Labor Act and the rights of workers. Payment for the service of workers should be done using only the legal tender, the country's legal tender. I am discussing the first provision of the Labor Act. The country's legal tender is the approved currency of Nigeria, in this case Naira. Therefore, it is against the law for an employer to pay his workers in dollars, US dollars, or British pound sterling, or some other currency apart from the Nigerian naira. Subsection A of that section 1 says that it is acceptable if, because of the nature of the industrial establishment or because of the industrial climate, the nature of job that the staff perform, that arrangement could be made to provide them with food, to provide them with dwelling places or accommodation, to provide them with drinks, to provide them with allowances of various kinds, like transport allowance and wardrobe allowance, and staff clinic, and so on and so forth, as a part of their remuneration, as a part, not the main remuneration, as a part of their payment. The payment, the salary will still come, irrespective of all of these added to it. However, on no account should an employer serve his staff in an intoxicating liquor or contraband drugs, hard drugs like heroin, cocaine, marijuana or Indian hemp, and cigars in general. On no circumstance should an employer serve his staff or workers with these. Now, let us take a look at subsection C. Now, payment can sometimes be made using representations of money like check, postal order, bank draft, especially if the worker has in writing requested that his payment could be made in this form. Section 2. An employer has no right to decide where, that is the place, or in what manner a worker is to spend his salary. An employer should not decide how a worker is to spend his or her salary or where to spend it. Section 4. We are only interested in those sections that affect workers. Therefore, from Section 2, we move to Section 4, which talks about advances, what workers usually refer to as a salary loan. Yes, a worker can request for a salary loan and obtain it from the employer. The employer can make such a pay advance, but the pay advance given to a worker must not exceed the monthly salary of that worker. So if the worker earns 100,000 naira, he can get a loan of up to 100,000 naira from his employee before the salary is paid, but not above 100,000 naira. Now, subsection B of 4 says that in the repayment of such an advance, the advance could be spread over a number of months, but not below 3 months. So the minimum number of months the payment could be spread is 3, not below. It could be more than 3 months, but not below it. And then subsection C. No worker shall be entitled to an additional salary advance when he or she has not finished repaying the previous advance he or she borrowed. But the employer could grant such an additional salary advance if circumstances dictate it. If, going by the prevailing circumstance, there is an urgent need to give the worker such an additional advance, then the employer could do so. Then, subsection D. In the payment of the advance, the employer is not entitled to any discount or any interest on the particular amount of loan given. That means the worker should repay the salary advance he's received over some months without the employer making profit out of it. So there should be no discount, there should be no interest attached to it. Good. Now, let us talk about 5, that is subsection 5 of the Labor Act as it affects workers. What does it say? The employer is not authorized by the Labor Act to make deductions from a worker's salary for the purpose of paying a named fine. So there should be nothing like surcharging the salary of the staff. But the employer could do so if this is done in order to compensate the employer for some injury he suffered due to the negligence of duty by the worker. But for this to be done, it must be approved by the head labor official, by the head of the trade union in that organization. The other kind of deduction, subsection B of section 5, the other kind of deduction that the Labor Act authorizes the employer is a deduction for the worker's contribution to an existing provident fund or pension scheme. For instance, in Nigeria, there is the contributory pension scheme. A provident fund is a fund that workers raise so as to help one another solve urgent problems. So this money forms a pool from which a worker in need can take some loan and repay later, usually without interest. So it is authorized by the labor law that the employer can make deduction for the purpose of contributing to such provident fund or pension scheme, especially if the state authority authorizes it and the worker has in writing accepted to be a part of such a scheme. The worker can also, in writing later on, decide to opt out of the scheme, in which case no deductions from his salary will be permissible. If there is an established or recognized trade union in the organization, the employer reserves the right to deduct a stated amount or to deduct a stipulated amount as each worker's contribution to the fund of the trade union. But this can only happen if such workers had in writing indicated their interest in the membership of the trade union. Of course, such a worker could still later reverse his decision by writing again to the authority of the establishment that he or she wants to withdraw his membership of the trade union, in which case deductions from his salary has to come to an end. I hope you've been following our discussion on the rights of workers, the do's and the don'ts of employers and employees. Now let's talk about the abuse of workers and the remedies, the available remedies. Who abuses the workers in a place of work? Sometimes a fellow worker who has been allowed to act as the image maker of the owner or CEO or entrepreneur or employer in that organization. First of all, sexual harassment, a situation that both male and female workers face in our industrial sector, but it is usually more on the side of the female. There are countless cases of female workers who have been denied promotion or whose salaries have even been withheld because they refuse to succumb to the sexual demands, to the demands for sex by their bosses or higher officials. CEOs or managers who have female secretaries are known to engage in sexual relations with their secretaries. And those secretaries who refuse can sometimes be dismissed when all other avenues have failed. They are denied promotion, they are denied salary increment when it is given to others, they are denied in-service training so as they can yield to the sex overtures of their superiors. Good. Now let us talk about male. Yes, there are female managers and CEOs who force their drivers into sexual relations. Otherwise, the driver could be dismissed. These are examples of abuses in the workplace. Now let's talk about physical assault. Yes, there are employers that go to the extent of slapping or even hitting their workers. And because workers are usually vulnerable, many of them bear it and continue to work because there is no other alternative. Thirdly, discrimination against workers. Discrimination can be based on gender. Yes, it is known that female workers who work at the same grade level or who perform analogous tasks with their male counterparts are sometimes paid lower than their male counterparts. Why are they paid lower? Because of their gender. And then some workers are denied promotion, are denied in-service training, are denied salary increment because of the religion they belong in, because of their ethnicity or their tribal origin. There are many cases of disabled workers denied training because they are disabled, and in some organizations, such disabled workers, even when they are qualified, are denied employment because of their physically challenged nature. These are all examples of discrimination in the workplace. Among others, we have not mentioned them all. Now, illegal dismissal. How should a worker be dismissed? First of all, the worker has to be called to order a number of times if the worker infringes the rules of ethics that govern the discharge of duties in the establishment. The staff has to be called order a number of times. Then queries would follow. After queries fail to call the errant worker to order, then usually there will be a suspension. A suspension with full payment of salaries. After that, the next suspension will be done without the salary paid. If this does not work, then it is time to dismiss the worker. And the dismissal is done quietly. A dismissal letter is served to the staff, and the staff leaves the establishment. The other workers do not have to know. Sometime in the past, I witnessed a record-breaking case of dismissal where an over-ambitious, wicked, and animal proprietor of a secondary school summoned a staff meeting, and after the house had been called to order, he told the staff that the vice principal, who sat near him, had been dismissed. There was no prior information as to why he was being dismissed, and the man who was dismissed had no idea that he was going to be dismissed that day. That is an abuse of the workers' right. It is a trampling on his rights to the dignity of the human person. Now, refusal to give or to issue an appointment paper to a staff is also another abuse of workers' rights. The appointment paper spells out the do's and don'ts of work as it relates to the employer and the employee. It provides for the condition of service, and so it's a binding agreement. So naturally, an employer who wants to do things his way and treat the workers just the way he likes will usually not issue them with an appointment paper. So that is an infringement on the rights of the staff or workers. We may now ask the question, remedies. What should a worker who is subjected to one or more of these kind of treatment do? The worker has to seek redress in the legal way. First of all, there is the Public Complaints Bureau or Public Complaints Commission, an agency of the federal government of Nigeria that settles disputes between employers and employees, especially with regard to those organizations that are registered by the Corporate Affairs Commission, CAC. What many workers do is to leave everything in the hands of God, but that is fatalistic. God cannot do for us what we can do for ourselves. You need to fight for your rights. Otherwise, others will keep taking your rights from you. The fact that you've decided to sleep over your rights and not make trouble will not make the oppressor stop oppressing. It will actually empower and embolden the rights violators to do more, to extend it to other persons. So you should report to the Corporate Affairs, to the Public Complaint Bureau, and they will invite your employer in a process known as ADR, or Alternative Dispute Resolution, and try to resolve the issue. Alternatively, you can report to the other human rights agencies that we have everywhere in the country. There is the National Human Rights Commission, where you can also report for ADR. And there are individually owned human rights organizations that even do it better. Like I've always said on this channel, if you have a problem deciding where to lodge your complaint, call our hotline 0806 5422 624 or drop your complaint on our email humanrightsheralds.wizard@gmail.com, or send me a WhatsApp post on the number 091-333-01790. While it is true that Human Rights Heralds is not a rights enforcement organization, but we are affiliated to scores of human rights organizations around the country, and this channel can link you to a human rights organization that can provide you with legal service if the alternative dispute resolution fails to resolve the industrial dispute you are involved in. You have no money to engage a legal representation. The legal rights, the Nigerian Legal Aid Commission exists with capital in all states of the Federation. The Legal Aid Council or Commission provides free legal service to indigent Nigerians who have serious rights cases but who do not have money to engage in legal representation to speak for them in a law court. Now, the third recourse is lawsuit or litigation. If it gets to the point where ADR fails and your only alternative is to go to court, we'll be there for you, like I've already told you. Your case is to be decided in the industrial court or failing a high court in any state of the federation. And then there are human rights organizations that will provide you with free legal service so long as you inform them, you get them informed about what you are passing through. And so that brings us to the end of this interesting session on know your rights, protect your rights, and defend your rights. The channel is Human Rights Heralds, and your usual host is Ogochukwu Onoha, the Human Rights Wizard. Remember that knowledge is power, and information hoarded is information void. Because of this, you need to share this video, like the video, subscribe to our channel so we can give you more of these kind of videos. I expect your comments on the comment section. Tell us what you think we can do to improve on our videos. Tell us what areas of rights you think we should analyze for the better understanding of members of the public. As I invite you to join me on our next video, I want you to remain focused, stay out of trouble, and be a respecter of other people's human rights so that you will have the moral justification to expect them to respect your own rights. Have a nice day. Bye-bye.